The Supreme Court.
Good morning, everybody. And thank you very much. Please be seated. And if you would call the case.
Good morning, Your Honors. The matter before the court this morning is the case entitled State of Vermont v. Jeremy Wells, case number 23 AP 395. Representing the appellant, Jeremy Wells, is attorney Sarah Starr. Representing the appellee, the state of Vermont, is attorney Maria Byford. Seated at council table with attorney Byford is David Newland.
Okay, thank you. Just if you would introduce us to David. Who is David?
Good morning. Mr. Newland is a law clerk in our office, and he'll be taking the bar exam in February.
Oh, okay. Well, welcome. It's nice to have you here. Thank you for that. All right, so we'll hear from counsel for the appellant court. Please come on up.
Good morning, Your Honors.
Good morning.
I'm Sarah Starr. I represent the appellant Jeremy Wells.
Thank you, Attorney Starr. Appreciate it.
Mr. Wells did not cause any damage to the bathroom of his jail cell.
Well, it's yeah, it is what the case is about.
This is what the case.
How do you define damage?
Well, in this case, nothing was broken, scratched, in need of repair or replacing. Nothing needed to be fixed, repainted, resurfaced. So the only damage alleged in this case was completely invisible to the human eye. And the only reason that Mr. Wells was even charged was because he was filmed while he was using the bathroom.
He was using other aspects of the bathroom than one might traditionally use.
So I think the state's position was that his use of the bathroom didn't meet sort of community standards, but what are community standards for bathroom use? I mean, he was placed, right? We don't usually, it's not something that we tend to observe and then judge. So he was placed in the cell. As far as he knew, this was his cell. This is where he was staying, and he used the bathroom and washed up.
Ms. Starr, is loss of use of the facility because of the cleaning up, is that damage?
I don't think that the state established a loss of use in this case because he was able to use it. He was in his cell. There was no evidence that there was somebody who needed to be in the cell, couldn't be in the cell, and that the city incurred charges finding other lodging for any individuals. And so the cleaning costs are maintenance costs associated with maintaining jail cells, which contain bathrooms in the same area.
We have a restitution statute in the same chapter, maybe not chapter, but the same volume, Title 13, that is the purpose of which I don't think we can disagree on, is to compensate victims of crime. And where there is some sort of action taken that requires the victim here, a police department, to pay money to have something remediated, that seems to be the purpose of the restitution statute. So here, under your arguments, there would be no restitution to the police department. And isn't that in conflict with our purpose of our restitution statute?
I don't think that it is. I think that you can't infer from the need for restitution that a crime occurred. I think you need to establish that there was the crime first, and then the compensation. I think also, in challenging restitution on this, were the cleaning costs reasonable under the circumstances? Were steps taken to mitigate? Could an officer have used a Lysol spray? Something like that. And
So Ms. Starr, let me take that one step from Justice Carroll's question. The restitution, the conduct with the restitution has to have a causal connection. And so to recover under the statute. So Are you saying there's no causal connection between the conduct of Mr. Wells and what is called damages? Because essentially, the bathroom hasn't been cleaned anyways. Is that part of the procedure or protocol for the police department that after a person is detained in the cell, then it's cleaned in any event before the next occupant comes into the cell? Do you know that?
I mean, thorough cleaning, I would hope thorough cleaning would be a normal part of maintaining a cell for individuals. And again, the standards of cleanliness are very subjective. And there are many messes that are made that we will never see because they weren't filmed.
So, Ms. Starr, would the method of cleaning matter depending on what needs to be cleaned? For example, stainless surfaces versus carpeting. Would that
I
make a
think-
difference?
I think that if it was I think there needs to be a change in the surface of the thing that needs to be cleaned. For example, there's a line of cases in New York where there's I think pamphleting or something where a very sort of a stubborn substance is used that changes the surface of the thing that it was adhered to, which differentiates it from, like sidewalk chalk that can be easily washed away. And so there was no evidence in this case that any of again, the mess was invisible, right? There was no visual mess. It was just that they had known that Mr. Wells had made contact between the surface and his genitalia. And so there wasn't, but again, there was no,
So is the urine different? Is the urinating different?
And
I-
the
it's-
spitting on the floor too.
And the spit,
well, and again, the allegations in this case was that he was spitting in the police cruiser and they didn't charge him for unlawful mischief for getting spit on the police cruiser. I think it's just so subjective that there has to be some type of more permanent or substantial damage that changes that converts the property into a different state.
So just to be clear, the record is clear that the statute talks about damage and intent. And intent, the issue of intent is not in front of us, right? Am I right?
Well, I think it is in that, even though I think Mr. Wells intended to use the bathroom, did he intend to cause a loss to the city by having them have additional cleaning expenses? And there was no showing that he had that type of intent, and that was the damage alleged, was the cleaning cost. And so I don't think, this was an extremely intoxicated individual who's, using the bathroom. I think if you want to talk about evidence of intent, he did use the toilet he urinated in the toilet. I think if he wanted to do more damage, there's more he could have done that would go to some sort of intent other than to wash up in the sink after using the bathroom.
So Ms. Starr, going back to the chief's first question, what's a workable definition in these circumstances of damages?
I think it has to be that it needs to that there needs to be a repair or a replacement and not just a cleaning. That it's, the case in New York that I cited in my brief, there were a water sprayed with feces on top of a building and it destroyed a banner. So there was a destruction and then there was a permanent dirtying that stayed and persisted for weeks because of the smell of the feces on the exterior wall. So there has to be some sort of change, something that's persistent, something that requires replacing, resurfacing, repainting. It can't just be something that can be washed away because it's too subjective. It would just open a door to just a wide array of conduct, chalking on sidewalks that some might find beautiful, some might find deeply offensive, or pets making a mess in somebody's driveway. Did the owner intentionally let the pet go to the bathroom on somebody else's property.
Does it matter here that this activity could be considered a health concern?
I mean, I think any sort, especially in the time of COVID and germs, like there's so many different health concerns and good reasons to, clean cells after use. I don't think that singling out this particular activity, even though it was distasteful, I don't think that that's appropriate. Because then, what is distasteful to one person might not be distasteful to another. And again, community standards in a bathroom, I'm not sure that that's something that we want to get into deciding, or if they even exist. So if there's no other questions, I'll reserve any time that I have left.
Thanks very much. Counsel for appellee, if you would come up. And please, before you start, introduce yourself, identify your client, and then proceed.
Good morning. My name is Maria Byford. I'm representing the state of Vermont in this matter.
Thank you.
Counsel, before you begin, you didn't comply with Rule 28. Can you tell this court, or at least tell me, what you view is the issue or question presented?
And I apologize for that. The issue in our estimation is the court of hearing me.
Yeah.
Is that better? In our view, the issue is the definition of damages, and we disagree with Ms. Starr's interpretation of damages. Damages, I think she even provided a Black's Law Dictionary definition of criminal damages as substantial impairment of the use of property. And that's what happened here. Even if it was temporary for a few hours, they couldn't use the holding cell until the next morning. They only have 2 holding cells. And I think there was testimony that there's something like 4 to 6 people rotating in and out of those cells on a given week. So they're not always full, but the fact that they had to take that cell out of use and they had to, wait until they could get someone to come in and clean it, is the issue for us. That's the damage. The cost to clean it is the amount of money that it took to fix the damage, which is also referenced in counsel's brief as the Black's Law Dictionary for damage, some kind of monetary compensation for, among other things, damage to property.
Do we know if this cell would have been cleaned in the ordinary course in between guest A and guest B?
I don't know that. I don't know that that was elicited. I do know that they had a regular cleaner and that's who they use, but they brought that person in specially. So my assumption, and I know that's dangerous to make assumptions, but what we were assuming was that they would not have necessarily brought someone in to clean it that morning. It might be like every other day or once a week. I'm not sure what the schedule was there. But I do think that council's confusing the fee to remediate the damage with the damage. For us, the damage is the fact that Mr. Wells rubbed his genitalia on various things. I'm not sure that there was even evidence that he did use the bathroom. He walked over to the toilet, and I think the testimony was that he appeared to be urinating, but I'm not sure that was even done. And I think if we look in the context of everything, of all the behavior that night, the defendant,
I'm sorry, you just stated that there was evidence that Mr. Wells appeared to be urinating, but you're not sure that was even done. So where in the record is that?
It is in the transcript. I could
Provide that to the court, please.
I don't have it handy, but I could.
Yes, please do that.
I certainly will. I recall, just because I was looking over the transcript recently, that Detective LeClaire, in fact, I actually think it's in one of the briefs, the whole testimony from Detective LeClaire. I'm sorry. So, well, maybe it's not one of the briefs. There was other testimony from Detective Leclerc, so I will get his citation. But from my recollection, he said that Mr. Wells walked over to, in fact, I think I have the quote here, that Mr. Wells walked over to the toilet and appeared to urinate, something to that effect. I have to paraphrase.
If you would provide it to us after
Yes.
the hearing, please.
And to that end, even if he had actually used the facilities, this is not a private bathroom. There's not a door. There's no right to privacy in a cell. And certainly he was aware there was a window and cameras. He had to know that he didn't have a right to privacy.
So do you agree that intent that's in the statute, that the question of intent is in the case?
I don't think that that was really well preserved by the briefing, but I understand that there might be some question as to that. But I think if you look at the circumstances, the context of the entire evening, with Mr. Wells spitting and uttering insults and spitting in the cruiser, spitting in the cell, as well as some of the offensive things he said.
But he pled guilty. Well, the jury found him guilty on those charges, on the spitting charges. That's not under appeal here. The only question under appeal is whether or not there was damage to the cell.
I understood. I just think that it's the context, the whole circumstances allow us to infer that this was not an accident. I mean, the testimony from Detective Leclerc was that the defendant wiped his genitalia across the top of the bench area near the toilet, and then standing in front of the sink with his genitalia over the top of the sink for a period of time before sitting down. I don't think we can say that that's accidental or it's part and parcel with using the restroom. And certainly the jury didn't find that. And the standard of review here is to give deference to the jury verdict unless the state didn't adduce any evidence that can sustain a verdict of guilt. In this case, we have a jury that's heard the testimony as well as saw the video of this behavior, and then they came back and rendered a verdict of guilty. So even though we're not talking about the other actions, I think, it all comes in context. That's the circumstances of what went on that night and why certain things were done.
So how would you define damages?
I think I would define them the same way that the Black's Law Dictionary did, as substantial impairment in the use of property. And when you have only 2 holding cells and you have to take one out of rotation, if you will, for a period of time so that it can be cleaned and sanitized. I mean, this isn't, I think one of you asked about the hygiene issue. I mean, this could be a biohazard. It's not just cleaning up a mess in the bathroom. And we also have to differentiate the difference between someone who makes a mess in the bathroom and clogs the toilet or does something like that, which is accidental, and something that's done deliberately. And just because the police video and observations caught this behavior, they felt a duty to remediate it. It's true that maybe they wouldn't have caught it and nothing would have happened. We don't know. But again, we're in a very germ conscious time in society. And this wasn't, it wasn't a minor.
But under that scenario, shouldn't they get cleaned every time someone uses it? Every time someone gets put into be like a hotel room. If somebody gets a whole hotel room for a night, chamber people come in, they clean it, and and leave it for the next person.
I don't disagree. I will say that the city of Newport is not the, most flush with cash, so I don't know what their standards were for cleaning it. And, you know, again, maybe if it looks on the surface that it's germ-free, they wouldn't call someone in. I know that they did have a regular person, but I don't know how regularly that person came in. Sometimes and I can say from experience, sometimes we'll get 10 calls a night, you know, and we'll have 10 flash sites or lodgings the next day. So people can be in and out of there. And of course, it's not just the one agency, but people, you know, there can be a time when they need to use both cells on rotation throughout the night, not just, you know, 6 times a week or something like that.
Would it matter in your view if this cell had been scheduled to be cleaned the next day?
Not necessarily, because again, you don't know that someone else might not need to use that cell on another date or later that night, and then they would have to take that person to VSP or somewhere else, which creates its own issues. A couple other points I'd like to make before I finish. Monitoring the holding cell is legal. It's done ostensibly for the defendant's safety. Again, there's no right to privacy. There was no private bathroom. It's not as if they had a camera in behind the stall door or anything like that, because there wasn't a stall. And anyone watching the video, it's clear that he wasn't just using the bathroom. Again, this is a limited, unusual circumstance. I don't think it's going to open up pet owners and people in public bathrooms to any kind of monitoring or penalty for maybe having an unfortunate moment. Again, we have to differentiate between accidental behavior and deliberate behavior.
Do we have to differentiate between criminal damage and damage in the civil context, or are they the same?
No, I think there is a difference, and I think certainly there might be a civil claim as well as a criminal claim here. But again, I think if we look at, even though intent wasn't really raised, it does, without seeing the intent in this behavior, it might be looked upon as accidental, in which case maybe it would just be a civil matter. But if we look at the belligerence of Mr. Wells and the other things he did, and admittedly, we could have possibly charged him for the spitting. We could have possibly charged him for an L&L, but the open and gross lewdness part was a little questionable. So this is where we landed, and it just seems as if you look at the context of the entire case, a whole night, Mr. Wells intended this damage. He may not have intended to cause the cost of a cleanup, but I don't think that's the litmus test. Litmus test is whether he intended the behavior that caused the cleanup. And again, the jury found that he did, and the standard review is not to disturb their verdict unless there's no evidence to that.
How about using a Google definition as the trial judge did in this case of damages? Any issue with that?
I'm not sure when he said we all use Google as a kind of a verb. Like I Googled it. So I don't know that he didn't go to Google and then go to, Webster's or some other, it doesn't sound like he went to Black's Law Dictionary, but I think that the court really just gave context. They kind of broadened the possibilities of what could be damage, but it still fits within the definition of Black's Law Dictionary, both for criminal damage and damage in a monetary sense. And certainly the jury didn't have any questions about that. So ultimately, I didn't think that was problematic. And I also think counsel's reference to the fact that Mr. Wells more accurately defiled the cell, I think that won't, I wouldn't disagree that he defiled the cell, but I don't think that means that he couldn't have damaged it. If there are no more questions, I'll
All right.
sit down.
Okay, thank you very much. How much time does the appellant have?
Appellant has 5 minutes and 23 seconds remaining.
Counsel?
Thank you. I did brief intent. I believe it's in the penultimate paragraph of the brief. This wasn't a long brief, so I think, but it was addressed in terms of that Mr. Wells did not intend to cause the loss, even if he did intend to use.
Was that, I don't know the answer to this, was that raised at the motion for judgment of acquittal?
Yes, I do believe that the attorney stated that he did not intend to cause the loss for the department. Although I can double check that. But in any event, there just was no damage. The state's own argument shows how speculative it is, how speculative the damages were, because the state was arguing that, there could have been people that needed the cell, but the state isn't certain whether anyone needed the cell or whether the cell would have been routinely cleaned. And so even if cleanliness is a standard for damage, the state didn't meet the burden as a matter of law, and the Rule 29 motion still should have been granted for a lack of showing of damage. And then as for the state's argument that this could have been charged as an L&L, I think that is just hugely problematic because, again, Mr. Wells did not choose to be in this cell. He was extremely intoxicated. He was placed in the cell. He didn't choose to be in the cell. He had no other bathroom to use. And so he had to use this bathroom, and he would have, I'm sure he would have preferred privacy. I'm sure most people, would choose privacy for washing up and for using the bathroom, but he did not have.
Star, another question that I don't know the answer to. Was there any objection at the time? I'm assuming there was a charge conference with the attorneys and the court. Was there any objection to the charge on damage that the court gave to the jurors?
I think that it was based on the court's ruling. The definition of damage was pretty vague, but the court, I think, did reference that damage could be the cleaning cost. And I don't recall if there was a specific objection to that jury charge in addition to the Rule 29 motion.
Well, the statute refers to any damage, right? So the implication of the language the legislature used is that it's a very broad term. Their intent was to characterize a very, very broad term. No?
I think that there still has to be damage and that a repair must be done. Any damage doesn't mean no damage. Any damage doesn't mean to make something dirty. I think that, again, that would be, under the legal definition, would be defilement, and there is a crime of defilement. Those things are more of like municipal violations, like littering and things like that are left sort of more to towns to regulate on a non-criminal basis.
So we really do have to look at intent, don't we?
I mean,
Although I thought I read in the briefs that both sides had waived intent out of the case, but maybe I'm thinking.
no, I mean, there was no intent to cause the loss. I mean, I don't think there was a dispute that the jury found that he was intending to use the bathroom in the manner that he did. So no, the intent to cause the loss is definitely an issue in the case. And then, but again, the central issue is whether there was a loss within the meaning of the statute, and there simply wasn't one. So, thank you.
Okay, Thank you. Please call the conclusion of the hearing.
The next hearing for the court is scheduled for 11:30